to Legally Speaking, with me, Tarun Nagia. On our series where we take up a lot of developments in international law, today we are going to discuss the Roe versus Wade judgment. Now, why is this important? In the year 1973, the Supreme Court has, in a sense, allowed women abortion, but that was overturned in what is known as a Roe versus Wade verdict, and that has sent shockwaves through the entire women folk all over America and sent a lot of wrong signals to the whole wide world. Now, why is it so? Because do women have a right over their own bodies, or can the court adjudicate on what they should decide? This is an issue that we are going to discuss today. Of course, in India, things are far more progressive, at least on this front, after we saw the overturning of the 1973 judgment. I have an eminent panel to discuss this with me. May I welcome Senior Advocate Neena Bhasin. She joins me on the show. I have with me Meghna Mishra, a partner from Taranjawala and Company. Good to see you, Meghna. I have with me Advocate Neha Nagpal, who joins us. And first come first, let me request Ma'am Bhasin to lay the ground, and then we move forward. Ma'am, over to you.
Well, Tarun, in my view, discussing the judgment of the Supreme Court of USA is only of academic interest. No doubt, overruling of the judgment of Roe and Casey by the US Supreme Court has taken the women community of the world, in fact, especially of US, by a storm. We have to see the reasoning behind the same, as given by the ruling of majority of 6 judges as against 3 who have dissented. The judgment relates to challenge made by a woman body to the Mississippi Gestational Age Act. Now, the act provides that except in a medical emergency or in the case of a severe fatal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be more than 15 weeks. Now, here what happens is the period within which a woman can go for an abortion is 15 weeks, which has been provided under this law, and the grounds which have been laid down for which she can go for an abortion are twofold. One is severe fatal abnormality or a medical emergency.
Okay.
Now, what does this include? We have to figure out what it includes, whether it can be termed very widely or whether we have to narrow it down. But the fact is that it has been narrowed down, and that is why there is a strong condemning. The dissenting judgment has condemned in many ways the majority judgment, and I do not know why there is so much of hue and cry, because there is still an exception carved, and they permit termination of pregnancy within 15 weeks. This judgment permits so. But what happens where there are so many state laws in US? I was just reading in the minority judgment. I was not able to go through the 213 pages, but I was reading in the minority judgment where it is basically, there are states which are having draconian laws where you are not able to, they are not allowed to even, there are no guidelines laid down on what basis, on what grounds you can terminate your pregnancy, within what period. It can be right from the beginning, from the inception, from the point of fertilization. So it is something which needs to be debated. This judgment is limited to a particular state. What about the other states? Why we are not looking into the laws which other states have actually enacted? And the reason why the reason which has been given by the majority judgment is that whether the courts, they have to find out whether it is deeply rooted, this law of abortion or the right to abort a baby, whether it is rooted in the American nation's history and tradition, and was that not implicit in the concept of ordered liberty? And so this they found it was not, and that is why they held this they've held that they have limited the period to 15 weeks. Now, in comparison to that, I feel that the Indian law, it is very, very progressive as compared to that, because it is given a lot more exceptions. I don't think so. In India also, I don't think so. I mean, it is a fact that in India, the termination of pregnancies cannot be at a will of a woman. So whether it is a fundamental right or not, it is again debatable. I feel it is not a fundamental right, because once you cross a particular, you don't come under the exceptions which have been carved under Section 3 of the Act, which is the Indian Act. If you don't come under within the exceptions, then what happens is, once you have conceived a child, you are actually, there's a conflict between a right of a woman who has conceived and a right of an unborn child. It is unborn child's fundamental right also to live life, right to life. And that right to life has been recognized by other laws in India. For example, a law of succession, Section 20, it says that an unborn child, if the father dies intestate, the mother dies intestate, the unborn child, if he's born later, will have the right to succeed to the estate of the father.
I'll take this issue to Meghna Mishra, partner with Karanjawala and Comfy. Ma'am, when this judgment came out, there was a sense of shock, and you could see it all over social media, that in a country like the United States of America, if such judgments can be passed, then it's not the right kind of indication that goes out to all the democratic world. Because, this is a slippery slope. You go down this path, and then orthodoxy can go up to any, we have seen, it doesn't stop at one place. Now, you are imposing things on women, which, the Supreme Court in its own wisdom, more than 50 years ago said that, women should have a right to abortion. How would someone like you look at this order, this judgment?
I think it's regressive to a large extent, simply because, and of course, I agree with ma'am to the extent that it does. Abortion always is a mixed question of law, which in every case, and we can discuss that further even in our country, how it's happened. But what happened in the US took it back, the first case that was filed was in 1969, then it came up to the Supreme Court in the US in 1973. So unfortunately, I feel that a woman's body has continued to be a site where the religious and the political battles and the legal battles are being fought. And I'm afraid that, this has taken, this has sacrificed the position of women completely, taken us back regressively. And you see, this throws also many issues of health, and it's not just about the choice, it's the younger lot which may not have been informed and has landed up in this situation. I think when you take away the right to decide whether or not you want to continue with a certain pregnancy, that's extremely regressive. In India, in fact, I'm extremely happy because in 2021, what did we do? We went from 20 to 24 weeks, and the other part, which only earlier, the Act used to talk about married women having the choice. In our 21 amendment, now we are talking about partners, and it is, embracing the social structure that we live in today. It gives you a choice. So in my view, I look down upon this judgment of the US Supreme Court.
Thanks for that opening comment. I'll go to Advocate Neha Nagpal. Ma'am, I want to ask you this. There are, when we see United States as a society, it has also a high incidence of young pregnancies, women in their teens getting pregnant with no means whatsoever to bring up a baby, not even the mental maturity to bring up a baby. Do you think this has much, this kind of a judgment will have ramifications which are much, much more than what we envision? How would you look at this development?
There that's actually a very pertinent question. And I think you're absolutely right. The ramifications, the tremors are being felt today, but the ramifications will only be felt over a period of time. It's very disturbing. The judgment, the act that came in under challenge anyway was restrictive in its nature, and therefore it got challenged. As compared to what Meghna ma'am just said, if you see the Indian Medical Termination of Pregnancy Act, it went from allowing Section 3 went from allowing 20 weeks and to 24 weeks. The concept of 24 weeks also came about in multiple cases. We saw the Supreme Court under Article 142 was passing repeated orders permitting pregnancy in cases of rape, in cases of where the mother was in a mental shelter home. So, and therefore that extra 4-week period carries those caveats. The week 1 to week 20 in India today, we have no caveats. You could be a teenager, you could be a married woman, you need nobody's consent. You literally have absolute right to your body. And now that choice could be made by a teenager, by a woman, because of financial constraints, because of mental constraints, because of just to exercise that choice. To take away that right in a society such as America, which is a lot more dynamic than the Indian society in certain ways, is very disturbing. It's not only is it disturbing from a perspective of the right to equality, but it's also disturbing from a standpoint of the right to privacy. The right to actually being able to make your own decision in life and not being such a personal decision in life and being restricted by the law is indeed very disturbing. And I think it's going to shatter the system very badly. It's going to lead to, what you call housemaid tales, to sort of to deal with pregnancies which are not going to be, which maybe teenagers, maybe women in their 20s, 30s would want to terminate, leading to more medical consequences.
You made a very important point, and I'll take it to Ma'am Neena Bhasin at this point. Ma'am, in India, we saw, and we know for a fact, that whenever there were these unwanted pregnancies, lesser known hospitals, unlicensed medical practitioners were used to terminate such pregnancies. There were infections. Many times women have passed away. They died because of this. It is a very serious issue. In fact, when we sit in Delhi, which is the national capital, many times you would not understand the plight of women in small towns of India who end up with, when they're not married and they get pregnant. I mean, these issues have much larger ramifications. But coming back to the judgment in the United States, a lot of countries of the world take inspiration from what happens in the United States of America. We have seen that countries which are less free have been taking inspiration, and a lot of laws have changed, saying that, okay, in America, which is one of the world's oldest democracies, things happen this way. So that becomes a justification to have changes in their own countries. Do you think when America takes such a regressive step, the impact is much more on the American society? It is much more on other societies also, because people can now go and say, look what America is doing. So where are we wrong in being more regressive? Do you think that we should look at these judgments sociologically also?
Well, Tarun, I feel that we have a codified law. So far as India is concerned, I feel that since our law is very comparatively more progressive as against America's law, which has been put in place by this judgment, which is very, very, as Meghna said, it is very, very regressive. It's a regressive law, and according to the dissenting judgment, it can cause a lot of formulation of draconian law. Draconian law in the sense that, as I said, from the very first day when a woman conceives, she will be stopped from even seeking the right to get her, termination of her pregnancy. So I don't think so. We need to look at a law which is regressive, which is also being condemned worldwide by all the women, and also the fact that we have a very good codified law in place. We don't need to look to America. I do not know how other countries and women association of other countries are going to look at it, but it is definitely not a very happy state of affairs.
It's not a happy state of affairs. And I'll take this to Meghna Mishra. Ma'am, America calls itself the leader of the free world. We have seen that in the Middle East also, things have changed looking at the American way. We've seen a lot of Middle Eastern people go to America, get educated there, want to bring things and open up their societies the American way. In fact, in many Middle Eastern countries, there are enclaves where the whole country lives under a different law regime, and those enclaves have a different law regime. When the leader of the free world, in a sense, a verdict is delivered, the Supreme Court there, do you think that the ramifications are much more in many other countries? For example, take India. Tomorrow, you may have an orthodoxy here speaking a very different language because, some judgment there in that country gives an opportunity to a certain class of people here to talk a different tune. And of course, there are every kind of people in each society. When the issue of gay marriages was discussed, that a lot of people talked about what's happening in the United States of America, and that was used as an example in the Indian courts of law. So do you think what happens in America has got a greater impact in other countries around the world?
Definitely, Tarun. And as the world becomes smaller, and with the social media taking instant update, instant discussion, of course it has a ramification. But that said, I think across internationally, everybody has frowned upon this development.
Yes,
of course,
yes.
It was something that was promised by Trump, when he was going to come to power, and that's of course the politics of it all,
Yes.
which we can keep aside for the moment. But as far as our country is concerned, I know that perhaps we are not looked at as the most progressive society with regard to women rights or
Yes.
just protection of women in general. But at least as far as this issue is concerned, our MTP Act, which came in 1971, we've already been on this path much before. And this was, of course, preceded by this commission in 1960s itself. That discussion had started. And in 1921, we have seen that an amendment came. So while, yes, internationally, those ramifications are there and we do talk about it, but it's not so easy to just put aside a statute which is a well thought of legislation, which has in fact given further rights. Like I mentioned earlier, now we have also included the partners and live-in relationships, or just teenagers who may find themselves, or young people who find themselves pregnant. Because, exactly what you mentioned, Tarun, the big fear, and not just in Delhi, but across in our country, is also about where does this leave women if they don't have a choice? Are more and more women exposing themselves to, unregistered practitioners who claim to, help you in this phase, where you end up just having further medical difficulties and unfortunately also a lot of times death.
Point well taken. I'll go across to Neha Nagpal. Ma'am, you were involved in the matter that involved the issue of gay rights and gay marriages. You have seen up close the arguments that happened in the Supreme Court then. And what happens is that, especially in the democratic countries, whatever happens is then used by human rights activists in not so free countries to advocate a free society. And whenever there is a regressive development in a democratic society, so to speak, its reverberations are felt through less free societies. So if a democratic society, like say the United States of America, takes a regressive step, it has a greater impact on less freer societies on the status of women. Do you think that democratic societies have a greater responsibility here? Because as we are all taught, the movement into regression and orthodoxy is such a slippery slope that one bad decision leads to another bad decision. And in the end, we've seen the status of women in many societies in the world where they are forced to live a life which is less than human. How would you look at this judgment in the light of the condition of women worldwide, not just in America, not in India, but the condition of women in many societies across the world?
So I definitely look at it as a very concerning time, we live in an era of instant, globalization, where the ripple effect is way more than what it probably was in, the early 1900s or even the early 2000s. Today, it's instant, as we've seen with how Twitter went crazy and with how Instagram was all over bursting with posts. So it's definitely very concerning. Definitely one bad idea does have the ability to give birth to many bad ideas in very many different places. And here I would really take to quote from the Indian Supreme Court in the triple talaq judgment, as well as in the 377 decriminalization judgment, where they very strongly took a position that the law and even the constitution, which is a living document, has to change with time. So they embraced the changes in society and did give enough credence to Article 19 rights, Article 14 rights, and Article 21 rights. So I'm sure, and I would choose to be an optimist here to say that this is a wrong, but I'm pretty certain that there will be a brigade which will stand up to correct the wrong, and I'm sure the international pressure that is building will also help with that.
Thank you for that comment. I'll go to Ma'am Neena Basin. Ma'am, I want your comment as somebody who spent so many decades in the profession. Do you think lawyers across the world, whenever they see such a development in any society, have a moral responsibility to raise their voice so that in any society, see, we have seen societies in Middle East, say Iran or Afghanistan, becoming much less free over the past 4 decades. Look at their status in the 60s and look at them today. So no society is immune from going into a path where orthodoxy develops. And somebody joked the other day, when societies become orthodox, all the orthodoxy is thrust upon its womenfolk. The men continue to live freer lives, but all kind of orthodoxy, you pass through the woman, she is forced to suffer. So do you think that the lawyers owe a responsibility that they take it up in each of their countries whenever such kind of developments, not even in America, it happens in any other society, lawyers should take it up? Your view on that?
Well, of course, Tarun, that is exactly what the lawyer should do. If there is something which is so regressive and which is going to is to the detriment of the right of a woman, to this extent that it is almost a draconian law which has been imposed upon a woman's right, I feel that it is a duty and responsibility of lawyers across the world to take up this issue and see that things are put in place and the women are given their respect, their right, the liberty, the right to privacy, to the extent as permitted by the social, economical, and moral environment which the country is having, that particular country has. So it is also a moral responsibility of the state to protect the right of a woman as against the right of a child, unborn child. You have to strike a balance. And that balance should be, as I would say, I am quite happy with the act which we have in place in India, which strikes a good amount of balance in it, which gives you good 20 weeks for taking a step. And what is very important is I see that there is one particular clause which says that mental health of a woman,
yes,
it is affected. Then we have to see how. If there is a failure of contraception, if she goes to a gynecologist or so if she says it's a mental health is being affected, and because of a failure of contraception, she has actually conceived a child or conceived the baby, then there is no way to show that she is actually, that actually the failure never took place. She has not taken precautions. You have to just believe it's a state of her mental health, which she's going to, kind of argue before the gynecologist. And gynecologist has no way to disprove this. So this itself is a big ground, a big, point which a woman who wants to terminate her pregnancy has for terminating her pregnancy within 24 weeks of her conceiving. So I feel that our law is so progressive, and also now it has gone beyond 24 weeks, that if there is abnormality seen in the fetus, then there can be also a termination after 24 weeks. But strangely, what I see in the Act, it does not deal with a situation where if the baby is normal after 24 weeks, but the mother is not in a position for any medical condition, to bear the child any further, then what is the situation? I feel there is a blank over there. I may be corrected by my colleagues on the panel, but I could not find anything as to how to deal with the situation.
Point well taken. We are almost out of time, so I'll take 1 minute comment each from Ma'am Meghna Mishra and then Advocate Neha Nagpal. Over to you, Meghna.
So very quickly, just to recap what my thoughts are: extremely regressive, devastating consequences across the world. India moving forward, fantastic act in place, and which encapsulates protection of the mother in case of her well-being being affected, and also, of course, the child. Supreme Court already dealt with a case, Sanchita versus State of Chandigarh, I think, where they dealt with the mental health of the person, whether she was mentally retarded or mildly mentally retarded, and they have discussed how our constitution has given a right to decide to women. Of course, that was not the core issue there, but I think we are miles ahead. So I feel India is in a good space for
India is in a good space at the moment. Neha Nagpal, your comment.
Yeah,
I absolutely agree with.
One very quick 30 seconds. We also need to keep in mind that in India, the girl child, the prenatal. So I think it ties up well while we're enforcing that. We also enforce choice to women. Sorry, Neha. Please.
Correct. I absolutely agree with you. And I really do think that the 2021 amendment to the Medical Termination of Pregnancy Act was very, very progressive. I think that for extra 4-week period, factoring in mental health issues, factoring in, the well-being of the unborn child is definitely a major step in the right direction. It has, of course, been a very conscious effort between civil society, Parliament, and even the Supreme Court, and at least a number of orders coming forth and passing orders under Article 142 to permit termination beyond the then 20-week period. I do think that it's time America and other progressive countries, other more evolved first world countries to take a leaf out of India's book, because at least in a place where India is dealing with being very high on its population, having a regressive stigma of, in a lot of, I can't say tier A cities, but still smaller cities in the country where there is a predominance for male child, but still, I think here empowering women to make that choice, not being dependent to get consent from anybody to take that choice, is really a very, very commendable step.
Thanks for that input. And we took up this issue because we will from now look at various judgments passed by courts all over the world. America is also important because, as somebody pointed out to me, people at a position of eminence in the field of law, many Indians have studied in the United States of America. It would not be untrue to say that, of course, they imbibe a lot of that society when they study. They also follow the courts very closely there, because once you've studied there, you got educated in America. Of course, that impression is never going to go. There are no such reverse examples of any American people coming to India to study law and going back. That doesn't happen. We go there. That's a fact. That can't be denied. So is there an impression of a development in America on Indian society? Yes, there is. There are a lot of other positive impressions. And if there is a negative development, it can't be said that won't have any impact. That's why we take this issue up today. But I would appreciate that Neha Nagpal, Neena Bhasin, Meghna Mishra from Karanjanal and Company found time to discuss this important issue with a huge sociological ramification. Looking forward to have you on more shows on important issues like these. Thank you, viewers, for tuning in. Thank you so very much.
Thank you.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.